Now, that I would make this submission, probably it might be repetition, that an authority or institution always go by institutional memory. They do not go by individual's memory. And when an authority affirms an affidavit denying the responsibility of the previous period, it seems he admits, my lord, that there were some irregularities. I just place the language. I say that, paragraph 3, I assumed office at the President of West Bengal Board on 24th of August 2022. I was not the President of the board when 2016 recruitment process was instituted and subsequently completed. The court did not want to know that whether you are responsible, but the institution was responsible. Then from records available in my office, it is evident that in the 2016 recruitment process, marks were given by the selectors, both in interview as also in aptitude test to the candidates. I would appeal to your lordship to read between the lines. Based on such records, I submit with utmost respect that the coherence which can be drawn thus far from such grant of marks by the selectors for aptitude test to candidates, thus far thereafter within the bracket, from such grant of marks by the selectors for aptitude test, is that such aptitude test was held. He does not positively say that from records, it is apparent that the aptitude tests were held. He wants to draw an inference on the basis of what? Since marks were allotted. Then paragraph 6, he now says what steps has he taken in 2022 recruitment process. And it's interesting, my lord, would please to read. In the 2022 recruitment process, which commenced after I assumed office, the board has taken various steps which are first of its kind. Therefore, it's an admission that these measures which would have protected the selection to maintain its fairness was not there. Then the interview and aptitude test of a candidate for the 2022 recruitment process is being taken, but I am not concerned with 2022. He was supposed to answer from records about 2016. Therefore, without this affidavit, in my humble submission, my lord, clearly admits then kindly come to 363, another affidavit by the president. Here, my lord, he describes from several authorities what aptitude test mean. I'm kindly not troubling my lord with this huge quotation from great authorities. I am not at all interested. Kindly come to paragraph 12.
It's 325. The 370.
The second direction contained in the order dated 24th of January 2023, passed by this Honorable Court, directs me to submit the list of interviewers at page 375.
I'm just wanting to see the 24th January order.
Yes, 24th January order, my lord, he was directed to file affidavit explaining the situation. 24th January order.
Yes.
The page 423, I am thankful to my friends.
Yes, Mr.
Yes. But the order says In course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test there are 5 marks. As a large number of petitioners were present in the courtroom, I decided to exercise my power under Section 165. Oath to 7 of such candidates being so and so, so and so, this is the order.
Yes.
Yes.
Now you are showing us para 12.
Yes. The second direction contained in the order dated so and so, passed by court, directs me to submit the list of interviewers who interviewed, took the aptitude test, so and so. I say that 2016 recruitment process was a district-wise selection. 2022 the center. Now they say 2016 was district-wise selection based on the opted districts of the applicant and candidate. The interview Vivabosi aptitude test was conducted at centers under the respective district primary school councils. And there is as such no distinctive record which was kept and maintained in such recruitment process, wherefrom it can be ascertained as to which interviewers took Vivabosi aptitude test of a given candidate at a given center in a particular room. In 2016 recruitment rules, no method was suggested. This is the difference. Are required to be maintained by the examining body. However, a full and complete list of interviewers available with the board. Only board maintains at the center the list of the interviewers. And they don't have any record to show at all the interview was taken or not. That is admission. On the face of such a serious allegation, when the court directs to file an affidavit, not an authority who is entrusted by law to hold the examination fairly in compliance of Article 1416, files this affidavit. Now, here, my lord will not find anything about the allegations made in the petition. Maybe that this was not directed to be do so. Then kindly come to another affidavit at page 378 by Dr. Partha Karmakar. Here he deals in detail. Now that he meticulously takes the point, it's not maintainable, this and that. Because the state authorities, when takes the point of maintainability, that should really raise doubt in the minds of the court about their transparency and impartiality. Kindly turn to Millard, page 389, paragraph 9 of the, sorry, Millard, before that, I missed one paragraph. Paragraph 8. Their whole attempt is to see that the petitions are knocked out on the ground of maintainability. These issues have been considered by the court. I shall come to later. They say in paragraph 8, that Rule 6.3 is applicable to all applicants who applied in 2060 recruitment process. There is no challenge in the said petition to Rule 6.3 of the 2060 recruitment rules. But why should I challenge? I rely on this. I rely to show that 6.3 has been blatantly violated. I shall test that. Then again, paragraph 9. But if I use this term, kindly excuse me if it is not suitable. But it's a fantastic defense, paragraph 9. I say that applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contained in writ petition. Now, this is an admission that they did not do so. They say that we have not been done. Delegated legislation does not provide us to do so. Transparency, go ahead. Article 14, 16, go ahead. And then further, the recruitment rules 2016 has not been challenged in the said petition. Such being the position, the answering respondents cannot be faulted not to have caused publication of the above in public domain. It's a clear admission they did not publish. However, in terms of the directions passed by the Honorable Court, the answering respondents did publish breakup of marks for candidates who were recommended from the 2016 recruitment process.
2022.
And that too, my lord, in terms of order dated 2022. And that's not the complete list.
Page 389.
389 to बोल रहा हूँ. Then paragraph 10, as I said, the defense of the recruitment authorities not to come up with records and say petition is not maintainable. I say that till paragraph 10 of the said petition, in paragraph 10 of the affidavit, the alleged grievance of the 140 petitioners were those which centered on 2016 recruitment process. In paragraph 11, the petitioners are dipped into 2020 recruitment process and made certain amendments. There is no amendment in said petition. 2020, we are not concerned. Then, in the 2020 recruitment, no untrained candidates are eligible to apply. That's not our grievance. Our grievance is 2016. Kindly come down to my lord, 3 lines from the bottom. On the date of affirmation of the said petition, I got it. 4 lines from the bottom. On the date,
Yes.
on the date of affirmation of the said petition, the petitioners are all untrained candidates who were unsuccessful in the 2016 recruitment process. In such view of the matter, the petitioners, as a matter of fact, not made out any case which calls for an interference by the Honorable Court. No denial of allegation of fraud and, all scam. Then, petitioners have failed to demonstrate existing any judicially enforceable legal right or breach in performance of any respondent legal duty warranting issuance of mandamus by this Honorable Court. It is categorically denied that the answering respondents intentionally ignored the petitioners as alleged or at all. It is categorically denied that although thousands of untrained candidates were recommended, the petitioners, though similarly placed, were ignored as alleged or at all. It is categorically denied that the relaxation given by NCT is applicable to all TET 2040 candidates who qualified TET as alleged or at all. On the contrary, it is stated that the relaxation given by the NCT applied to those applicants who applied for the recruitment process. This is a fraud on statute. I shall explain. Then will kindly skip over. I am not detaining with further readings. Page 392. Well, that 4 lines from the top. Unless further details. Now, my lord, now the burden is thrown upon the candidates that they have to get all details. Unless further, got it? Unless further details are furnished by the petitioners pertaining to alleged Mr. Y, having roll number such and such, the answering respondents are unable to deal with such statement temporarily reserving the right to deal with the same subsequently upon disclosure of further details. What nonsense is it? Records are with you. You are privileged with the records and you want me to produce it. Is that the law of evidence says? The answering respondent have no knowledge about the alleged different statements given by his previous president and accordingly refrain from making any comments thereon. Such refraining, it is made abundantly clear, is not an admission of the statements. The answering respondents further say that the petitioner failed to establish that there has been any pick and choose between the candidates. I have given 2-3 examples. You could have come up saying that his marks is X. We have given appointment to Y is higher than X. And now there are 100 petitions pending before this court. To summarize everything, I have just prepared below the chart of rank jumping. I shall hand over to it, Lordship, to your Lordship. This is the affidavit in detail by the board. Kindly come to the paragraph 19. The specific pleadings in the petition when they were touched. It is stated that by the order
Page 395.
396, paragraph 19.
Yes.
It is stated by the order dated 20th December 2022, this Honorable Court directed the answering respondents to come up with the particulars in tabular form. The marks obtained by last empanel candidates of different categories and different mediums of all districts. In compliance thereof, the answering respondents bid a memo dated so and so submitted the list of petitioners along with the breakup of total score together with the breakup of total score of the last empanel candidates in the respective medium, category and district wise. The said direction was furnished in a tabular format before the Honorable Court. Such report is annexed. It is then, my lord, if upon examining the said tabular chart, further queries are required to be addressed, the answering respondents are willing to explain them. Is it not withholding? The court will direct, then only you come up with your defense. The answering respondents categorically deny that the report is absolutely bogus as alleged at all. It is clarified that if at any stage of the selection any ineligibility is detected by the examining body, then the candidature of the applicant can be rejected at any point of time. It is not a correct appreciation of the position of law that if at the time of scrutiny or verification a candidate clears his scrutiny verification, he or she cannot be declared as ineligible before or even after being recommended. In other words, if a candidate upon crossing the hurdle of scrutiny and verification is permitted to sit in the interview aptitude test, the right of the examining and recommending body to recheck, revisit the candidate eligibility is not wiped out. Any allegation against such a contention is emphatically denied. Furthermore, a candidate is rejected, the examining body is obliged to inform him the reasons, see the audacity. The reason of such rejection under the applicable statutory rules. It is categorically denied that the report filed by the examining body is absolutely bogus as alleged at all. It is further denied that the report is absolutely false as alleged at all. Well, the denial is that it's not absolutely false, partially false. The Deputy Secretary of the answering respondents complied with the order of this court. Then, my lord, will kindly come to paragraph 20. I say that not in respect of one candidate, Noor Huda Khan.
Yes.
In the present proceeding, where the prayer is for treating the writ petitioners equally with recommended non-trained candidates, the issue may not be gone into. However, if this Honorable Court passes a direction, the alleged ambiguity pertaining to Nur Huda Khan can again be looked into by the answering respondents. It is categorically denied that intentionally marks of the petitioners were reduced while submitting the report of before this Honorable Court. Certain RTI query answers are cited to demonstrate that the incorrect report was submitted. Such RTI answers keep to be thoroughly scrutinized, if necessary, before arriving at any conclusion. But does it not show that the authority was trying to evade the responsibility? Now, these are the pleadings. And if your lordship really goes by this pleading, what is the outcome of it?
Relaxation.
Outcome is there has been allegations by a candidate of gross irregularities, corruption, fraud, and the authorities filing affidavit says we are answerable only when the court asks to answer, not otherwise. নোটিফিকেশনটা কবে হয়েছিল? না, একটা কথা রুলসটা
The relaxation notification.
না না রিক্রুটমেন্ট নোটিফিকেশনটা
এই রিক্রুটমেন্ট নোটিফিকেশন
ডেট কবে জানো?
26শে সেপ্টেম্বর 2016।
নাকি? Now, my lord will kindly take the trouble to come to the recruitment notification at page 120.
Pertaining to this candidate why an explanation was given, which was submitted request. Ask your junior to just to recollect, we have taken that on record. That what is your candidate why was it was so far as I remember, candidate why the name was not given. Subsequently, document was document. That submitted by Mr. Sen.
Because of the internet features, my lord, the full name was not given by the candidate.
This was a reply on their part. So please,
The full number was there.
yes.
I shall see their reply. Kindly turn to recruitment notification at page 120. The copies you may need a microscope, but
করার দরকার নেই স্যার।
the
না না যেটা
না।
কপি ওদেরকে দিয়েছে
I'm just reading out, Lordship may.
only স্যার ডেটটা
This was dated 27th of September 2016. Date is important.
Page 100
20. Justice Mitra got it. I have a better copy. Oh,
yes,
shall we note the date? Nothing else. 27th September 2016.
26.
26
26. Anyway, I am not able to read it.
Yes.
And this notification was issued on 26 September 2016. And let us see what was the relaxation given by the NCT for non-trained.
Page 95.
Kindly turn to page 95. তিনিক থেকে দাও সাগরদা দিয়েছে কি দিয়েছে দরকার নেই yes
Taxation was extended, Mr. Bhatia,
I'll come to that. Therefore, on that date there was no relaxation.
on 26.
26th of 2016 there was no relaxation. Relaxation came to an end. Kindly come to page 95.
Yes. Page 95, yes.
Yes.
Relaxation up to 31st March 2016.
Yes.
Yes, subject.
Yes. Relaxation was up to 31st March 2016. Therefore, on the date of notification, recruitment notification, the relaxation was over. Therefore, no one who was not qualified on that date could have got the benefit of relaxation. Now, I will come subsequent amendment. Therefore, on 26th of September, the relaxation granted on 9th of April 2015 had no force.
Three proviso goes.
Yes.
That's our point. I agree.
That has not been the case in the petition.
Well, I would again say, my lord, it's pure,
This was never a point in the
my lord, it's a pure question of law.
everything
এটা নেওয়া হয়েছে এটা নেওয়া
that government trustee entrusted we took note of that submission. But Mr. Bhattacharya, in the writ petition, the argument which you are making is not there. It
Yes, yes, yes.
there was no
I have read it.
was that line
I have read it. I have read it. I just,
expiry after
well,
expiry.
I have said that there was no relaxation. I have said so in the petition.
So relaxation, you are building that argument, Mr. Bhattacharya, with support of some element.
Yes, yes. Kindly come to, my lord, the writ petition pleading.
yes.
I just read out that there was.
Let Mr. Dasgupta check it up. Proceed.
Yes, let me check.